All right, good morning, everyone. Thank you for joining us. I'm going to go ahead and turn it over to Clerk Tiffany Moore Russell to get us started.
Thank you, Jared. Hello, everyone, and thank you all for joining us for the Know Before You File attorney training, where we're going to discuss important changes to civil and small claims filings. So as of July 1st of this year, due to a recent Florida Supreme Court amendment to Rule of Judicial Administration 2.420, the responsibility will now rest on you, the filer, to protect the personal information of your clients. Whether you are an attorney or you choose to self-represent, the filer now needs to notify us, the clerk, of any confidential information that needs to be redacted in any civil and small claim court records filed with my office. So this amendment rule affects all small claims court filings and some circuit and county court filings, except for Jimmy Rice, civil commitments, cases stemming from sexual assault, and medical malpractice filings. This rule change will not affect family, criminal, and juvenile cases. Our goal this afternoon is to equip you with information on how to successfully protect the confidentiality of these records as we continually explore long-term solutions to streamline this process. So I want to give over to you the two representatives from my office who's going to go into more detail. First, Jared Brooks, our General Counsel, and Melissa Geis, Director of Court Operations. They will cover procedural updates my office will implement to address this matter. Question and answers will be conducted at the end of this presentation. So if you have questions, please utilize the raise your hand feature and my staff will acknowledge you during that section of the meeting. So once again, thank you for joining us today and enjoy the rest of this presentation. Jared, I give it back to you.
All right, thank you, Clerk Russell. Just give us 1 second so we can share our screen with everyone and we'll go ahead and get started. Beginning. Okay, I just want to make sure, can everyone see the screen that we have up with the training? That should be the opening slide of attorney training, important changes to civil and small claims filing. So hope everyone can see that. As you just heard Clerk Russell give the opening introductions for our agenda for today, Melissa Geis and I will provide some Rule 2.420 updates and some operations impacts. And then again, we will close out with Q&A and some closing remarks. And just for what it's worth, we have allotted for quite a bit of time for Q&A, so don't feel as though this presentation will take up the bulk of the time. We really want to give you all an opportunity to ask those questions, whether it's from a legal perspective or an operational perspective. So just want to give a brief history of the rule update so you can kind of understand how we got here today. So on January 21st of 2021, the Florida Supreme Court, on its own motion, issued an opinion that amended Florida Rules of Judicial Administration 2.420D that was going to be effective July 1. And so moving forward, you will hear me refer to the Florida Rule of Judicial Administration as the RJA. Just as you can imagine, it's a mouthful to say that whole thing, okay? So that amendment stated, and I quote, "In certain civil cases, the clerk of court shall not be required to designate and maintain information as confidential unless the filer takes certain actions." So as you can imagine, that language as far as the shall not be required really could be interpreted in multiple ways. So on April 6th, 2021, the clerk submitted comments to the rule amendments to seek clarification on the proposed language. But then on June 10th of 2021, the Florida Supreme Court issued its final order, making no changes to the January 21st opinion. So that put the clerks in a situation to have to, again, do some legal analysis and interpretation to understand what the court really meant by that shall not be required. But after doing some research and, again, much discussion amongst the Clerks Association, we took the court's failure to further amend 2.420 to clarify the clerk's role to lead to the assumption that the court does not question the meaning of the chosen language. So there was some other support for that opinion, which amended the rule, wherein the court stated its intending meaning of the language as follows, is that the clerk does not have an independent responsibility to identify and designate information as confidential. Instead, that is the sole responsibility of the filer. So I think it's important to note, and something that Clerk Russell and our entire team has discussed at length, is that it's important to educate the bar and inform you all of this rule change, because what is also included in the Florida Supreme Court's opinion is that, and I quote this as well, we also emphasize that any party, non-party, or attorney who does not comply with the requirements in Rule 2.420 may be subject to sanctions under each subdivision of a different provision of Rule 2.420. So again, although this is not, again, an exhaustive training on the entire rule of judicial administration and everything that's, within 2.420, again, we would like to, again, hopefully educate and inform you all of this change. But I do encourage you all to familiarize and educate yourselves of 2.420 and some other relevant provisions of the RJA related to confidential information. So let's do a brief overview of the rule change. And as you heard me mention on the previous slide, that the clerk of court no longer has an independent responsibility to identify and designate information as confidential. So that is now the sole responsibility of the filer. And as Clerk Russell stated in her introduction, this only applies to circuit civil, county civil, and small claims cases, with the exception of Jimmy Rice civil commitments and cases stemming from sexual assault and medical malpractice filings. So for practitioners that are looking at, that handle family cases, criminal, juvenile cases, this does not apply. We will continue to auto redact confidential information in those case types. So you've heard me mention confidential, and I think it's important to define that. What is considered confidential? So in 2.420 subsection D1B, there are currently 23 categories of information that are designated as confidential. So these are the only categories of information that the clerk's office is authorized to designate and maintain as confidential, absent a court order. So I know that I've received, sometimes me or whether it's our other staff receive emails or calls about sensitive information or an exemption that may be found in Chapter 119 of the Florida statutes. And so I think it's important to note here that it is well established that the rules of judicial administration govern court records, not Chapter 119. So there may be an exemption for a certain class or category of information under 119. But again, I want to reiterate that it is not included within that 23 categories of information. The clerk does not have the authority to designate that information as confidential absent a court order. So what is included on the 23 categories of information, which clerks affectionately refer to the list of 23? And as you can see on the slide here, there are the types of information, of confidential information that can be redacted. And so, again, I won't read off each of the 23 because I'm sure everyone here can see that on the slide, but I will mention one that I know jumps out at people quite a bit is the social security numbers, bank accounts, charge and debit card, credit card information that, you can imagine that information being out could be problematic for your clients. Or if you're a pro se litigant for you. And so again, prior to the amendment, these are the categories of information that the clerk's office was automatically redacting as a matter of practice. However, effective July 1, we no longer have that authority to maintain that information as confidential. So I'm sure that leads to, how do you maintain that information as confidential moving forward, effective July 1. So in a limited group of cases, again, as we talked about the circuit civil, county civil, and small claims, the Florida Supreme Court opinion and rule indicates that the court will designate information as confidential only in 2 instances. One of them is when the filer completes a notice of confidential information within court filing at the time of the filing. So again, this is important because we need you to identify in that notice the precise location of the confidential information or the document when you file that notice. And I mean, that includes your page number, where it appears in any appendices, attachments, or exhibits, as well as identifying the type of confidential information or the provision that applies. And I'm going to turn it over to our Director of Court Operations, Melissa Geis, to explain a little more from an operations perspective why that's important, and maybe some other information as it relates to filings.
Thank you, Jared. As most of you know, as lawyers within the community, the civil division is one of our busiest divisions. On average, we receive about 4,000 pleadings filed through the Florida ePortal daily. Once we go through those pleadings, our office approves them, which then sends them into our case management system for further processing. Prior to July 1st, it would go through our auto redaction. All of those things that Jared just mentioned would be auto redacted. Come July 1st, those will be approved, go directly into the case management system unless you file your notice of confidentiality. Once the notice of confidentiality is filed, our office has a process that locks the document for a minimum of 5 days for us to review that document and identify those redactable candidates. If we find that they do not qualify under the list of 23, we will notify the attorney's office to give them an opportunity to file a motion for confidentiality. The document will remain locked until there's an order from the court denying or granting the motion. One of the things to remember, as Jared has mentioned, and we'll go into a little further detail, the notice of confidentiality should be very specific. The location of the information within the document, down to the line, the page number, and the exact wording. This will allow our clerks to know exactly what confidential information you're requesting be redacted.
Thank you, Melissa. And just to give a visual, so this is what the notice of confidential information within a court filing looks like. And to Melissa's point, where you can see the title type of document, designating whether the entire document is confidential, or whether the confidential information is included at precisely what location. And again, we can't emphasize how important it is for you to be as specific as possible, because again, if clerks, if that information is not specific, a clerk, we're not able, again, to just assume that it's there and redact or keep the maintain that information as confidential. So you can imagine if you're filing, whether it's a complaint or any filing in your case, without that, our clerks would have to literally go through the entire document in order to find that information. And that's not something that we're able to do. So again, we want to stress the importance of the precise location and really to maintain that information as confidential for your client. So as you heard Melissa mention just now, that again, if you file your notice, but the information is not considered confidential because it's not in that list of 23, again, we'll lock it down for those 5 days, up to 10 days, assuming that we do not believe it's meets the requirements of 2.420, and then give you 10 days in order to file your motion to determine confidentiality. So again, once the court makes once you file your motion to determine confidentiality, clerk we're not intervening on that matter. We have no position on that matter. That is between you and the judge at that point. And once we receive a court order, we will adhere to that and maintain that information as confidential, assuming that's the court's wish. But again, if no motion is filed after 10 days, please be advised that information will become public. So again, if you receive that notice, notification from the clerk's office within those 5 days that your filing is not considered confidential due to it being outside of the list of 23, then I would encourage you to expeditiously file your motion to determine confidentiality of court records, because per the rule, once we get up to 10 days, again, we will make that information public. I think it's important to note here, though, that the notice of confidentiality, for the sake of terms, is not necessarily required prior to your motion to determine confidentiality. And what I mean by that is, again, we've given you that list of 23. You're aware of the list of 23. If you know that your information, your client's information, is outside of that list, you can go ahead and file your motion to determine confidentiality. If you believe in good faith that information should be maintained as confidential, while it may not be within that list of 23, again, that's a matter for you and the court to work out. And again, the clerk has no position on that matter. We will again adhere to whatever the court's wishes are. And so I don't want anyone to feel as though if you look at the list and know that it's not there, that you feel as though we are required to file a notice. You can immediately go ahead and file your motion, which again, we will lock down until the court rules on that motion. So for convenience, and again, because again, this is a new rule change, and as you heard me mention that we just received word of this in just a few weeks ago, we created a web page that includes most of the information that we've discussed today in a more condensed fashion. So on myorangeclerk.com /know before you file, you'll find the amendment to Rule 2.420, the Notice of Confidential Information form, as well as that list of 23 that Melissa and I have referenced throughout this presentation. So again, if you have questions about what's on that list, if you have, you or your staff are preparing, your pleadings and wanting to know what information is considered confidential and what isn't, again, you can visit this website here, and that will direct you to our information on the clerk's website. And then one other thing I just want to point out for clarification purposes is that although this is the 9th Judicial Circuit, we are the Orange County Clerk of the Court. Osceola County, excuse me, try that again. The Osceola Clerk of Courts is a separate agency that may be handling this differently. We can't speak to that. So I don't want anyone to assume that what you're hearing today in Orange County applies in Osceola County. You would need to contact their office to determine how they are handling this rule change. And so with that, as I promised you, we want to leave as much opportunity for questions and answers or offer any clarification that we can. We'll open it up for questions. Oh, screen is visible. Good to know. Probate. I'll stop share. Okay, so we have a question from Sylvia McLean about what about probate? So no, probate is there's no change to probate at this point. This is our circuit civil, county civil, and small claims. So there's no change to probate. We will continue to maintain those records as confidential as we've done as prior to this amendment to the rule change. So Sylvia, I hope that answers your question. And I see we have Samantha Stevenson, I'm going to assume. We'll go ahead and unmute you.
Hey, if we have an order in a case that certain information is to be kept confidential, and it's not included in one of the lists of 23, do we just file a notice of confidential information and reference the court's order?
So let me ask, I guess from a process perspective, I mean, that's one way to go about it. I can tell you that I'm sure if you already have that court order and our office is made aware of it, again, we're going to maintain that information as confidential, because that is one of the provisions under the rule, is that it says whether there's a notice to determine confidentiality, a motion to determine confidentiality, or excuse me, a notice of confidential filing, a motion to determine confidentiality, or by court order. So if you have that court order, you're not required to do the notice. But again, we would just need a copy of that so that our clerks could then maintain that information as confidential.
Okay, thank you.
Thank you. And I know if anyone else has questions, again, feel free to raise your hand and ask. I also want to put out, because something that we've discussed internally is what about any cases that were filed before July 1 of 2021. And so while we're not going back and just assuming that we'll go back to the unredacting anything from those cases, if one of your filings that, let's just say that's July 2nd, and you have a case that was filed, today, June 28th, you would need to, at that point, as effective July 1, file that notice of confidential information within a court filing. So just because you had a case that was initiated prior to July 1, again, effective July 1 moving forward, we will then be implementing this process. So I don't want anyone to assume that just because you had your case filed before that you've been grandfathered into this. Again, any filings in that case that come after July 1st will fall under this amendment to the rule. Does anyone else have any other questions, comments, concerns? Okay, I see from Kimberly Shillette. What if we redact a document? Okay, so the question is, what if we redact a document before filing it? Will we still need to file the notice of confidentiality? So in reading the rule, and Cameron, this is a good question because this has come up quite a bit, whether it's around the Clerks Association as well as internally. If you decide to redact a document before filing it, you would also need to file an unredacted copy of that. The way the RJ reads is that the clerk ultimately makes the determination as to whether a document meets the criteria in 2.420. And so, you know, if a filer is just redacting information, there's no way for the court or the clerk to even know what information was redacted, whether it fits within a, you know, one of those list of 23, or, you know, and for us to work that process. So while we do receive some filings that are redacted, we still need you to file the redacted version, because at that point, we wouldn't have an unredacted copy to provide to the court, nor would we be able to determine whether or not the information that you've redacted meets the criteria in 2.420. All right. Does anyone else have any other questions? And while you're thinking, I'll just also point out, this is obviously, again, a rule change that was finalized, again, just what I'd say June 10th. So you can imagine that our office has done quite a bit of work leading up to that as we followed this throughout the process since January. But also, again, just evaluating our process, taking a look at what needs to be tweaked. And if something we're doing today, isn't effective or doesn't work, of course, you can trust that we're going to make those adjustments and again, find the best way to go about that. So from Carter Young, is the notice of confidentiality in itself confidential? So the answer to that question is no. So that will show up on the docket. And Melissa, correct me if I'm wrong with that. But if someone files a notice, you'll see that there was a notice of confidentiality filed. Now, I'm sorry.
Okay.
Now, if it's determined to be confidential, then the information within the documents will be confidential. If you'd like for the notice of confidentiality in and of itself to be maintained as confidential, that would have to come from the court. Unless if I'm wrong.
That is
please.
correct.
Okay.
Yes.
So Carter, I don't know if that answers your question. Thank you. So again, it's just any other questions that anyone may have or thoughts for us? I'll give it a few minutes as people might be thinking through some scenarios. Okay. Well, don't see any other hands. Oh, I'm sorry, Sean McCleve. So as the family law cases, there is no change change to how things are processed, correct? Yes, that is correct, Sean. There's no change on the family case type, so there's no need to, we will continue our process of automatically redacting the confidential filing, or the categories of confidential information in those filings for those case types. So family is excluded from this amendment. I see from Michael Bradley, are we able to address errors made by opposing counsel? For instance, they forget the filing and exposes our client. Are we able to address errors made by opposing counsel? So that's a good question. I'm trying to think from a process perspective. So I'm assuming that you mean if you notice that something should have been maintained as confidential, or at least identified as confidential, yet it wasn't. And so you want to then go in and maintain that for your client. I would say that, yes, you're able to do that by filing a notice of confidential filing within the court file, or confidentiality within a court filing, because that's the only way we would know. So if you notice something in a proceeding that your client's information is out there, at that point, you would then need to intervene and file something. Otherwise, we wouldn't be able just to automatically do that without that notice, even though it is in our pleading. Yeah, you would need to file that. And Melissa, do you want to
Correct.
Yeah.
It would be the same process. If you file it, we would lock it down, review the case file, review the pleading, and then determine whether or not it meets the criteria.
Yeah. So I guess to answer your question is, even though it's not your pleading, no, I would say you need to then file a notice of confidential information with the court filing in that case, identifying where, again, with specificity, where that information is, by page number, exhibit, and so forth, so that we can make sure that it's there. And then, of course, if you and opposing counsel have a disagreement about that, that's where that motion to determine confidentiality may come in, where, again, we're not, at that point, the clerk's office has removed itself from, I guess, the process until we receive something from the court finalizing that decision.
Can you tell me how fast that happens? Where we see this happen is subsidized housing cases, and our client's social security numbers get filed. And then I've been told in the past that I can't lock down somebody else's filing. And so in the interim, my client's social security numbers and those of their children are available. And so how fast would that happen?
It would happen as soon as the pleading is approved through the portal, once it gets into our case management system. That's where there tends to be some confusion. When y'all file to the Florida e-portal, it doesn't automatically make our case management system. So depending how many pleadings are ahead of you, because it's definitely first in, first out. But a scenario like that, I would recommend an emergency filing. You know how you have that emergency button, just so that makes it to the way of to the top of the list, and we can get that locked down as soon as possible.
You're welcome. So do we have any other questions? Again, feel free, whether you want to raise your hand, speak in, or enter something into the chat. Take questions in either avenue. And again, in the meantime, just as people may be thinking, I think it's important to, again, to speak on what Melissa mentioned about the volume of filings we receive, and quite candidly that there's indication that there may be we may see an increase in the number of civil filings in the coming months, whether the backlog through the pandemic or any or just other factors. And so again, that's very important point of information that Melissa shared, as far as when you file it, that doesn't mean it's hit our case maintenance system. So again, you may think, and I get a few calls, Melissa receives calls that someone says, oh, I filed this, but I don't see it. Again, it's in the e-portal, but again, we have to work our process and then accept it from the queue. So don't panic when you see that, but again, the emergency filing, we'll definitely, bump it to the list, top of the list. So from Griffin Hall, do you file the notice of confidentiality at the same time as the pleading or prior? At the same time. That's what the rule says, at the same time. So that way, when our clerks see it, they'll, when they accept it, they will see that notice and then work through that. And Melissa, I'll let you explain kind of what the clerks.
That's correct. It's a very identifiable document. And once we see that, we know to go in and lock the document pending the review. So it's best if it's filed at the same time, because it could delay in getting it locked down if we have to go and look for the document if they're filed separately.
Right. And on top of that, we wouldn't really know. I mean, at that point, you're staying with specificity, but we wouldn't, if it was prior, we wouldn't know what to even look for. We wouldn't have a document to look at yet. So, as she indicated, it's a very, identifiable filing. And again, and just for what it's worth, I mean, we have obviously, as we're doing this training for our partners, with the local bar, or just the bar around the state. I mean, I see some people here that don't live in Orange County but may practice here. We've done a lot of internal training as well with our clerks. And so, Melissa, I don't know if you want to maybe share that with the group as far as some things we've done internally to, help our clerks be prepared for this change.
Yes, we kind of had some of the same training we're having here today with our front counter clerks to help those individuals who might be filing confidential information and they're unaware of the change, as well as just explaining the start to finish process, that here's where we lock it down, here's where we wait for the court order if the motion gets filed, and what our process is to make sure nothing gets missed. It's a interesting process from start to finish from a clerk's perspective, because if the notice of confidentiality is not specific in where the information is within the document, it does become, like Jared expressed, we have to kind of dig through that and determine that on our own. And that's one of the things we want to avoid. We want the notices to be very specific in what information you want kept confidential.
Thank you. Okay, we have a question from Robin Jackson. So if you are filing a motion, then you will also be filing it at the same time of the pleading or document. Yes, that is correct. We want those documents to come at the same time. So that way, again, we're able to recognize it, lock it down, then go ahead and follow through our process of looking through the list of 23, identifying where it is, and then again, having that information redacted. Or conversely, if we see that it's outside of that list of 23, then sending you your notice within the time standards, so that you're able to then take the next steps as far as maintaining that document as confidential. Okay, so for Ms. Harani, if you have redacted the social security number except last four, you still need to file a notice of confidentiality. No, so that's a good point. In a separate rule, which is about minimizing information, and that's, I don't want to quote it here because I don't have it right in front of me, but it's still in that 2.4 part of the RJ. You can redact parts of the social security number as far as like having the last four or something of that nature. So no, you don't need to file the notice of confidentiality there unless you want us to completely redact it, because, Melissa, correct me if I'm wrong, but if we receive that notice, we'll just redact the number altogether. We don't leave the last four.
That is correct. We redact the entire number.
Okay. And that's and I'm actually glad that question came in. Is also, and this is maybe again not to tell anyone how to practice but just kind of put it out there as a talking point amongst clerks. There may be information that is not necessary that sometimes makes it into a complaint or a pleading, and so it may be worth thinking about when you're putting information in certain documents to say hey, is this necessary? Is a bank statement that's in there, do we need to have that in there, or is a social required? And it may be, and that's perfectly fine, and that's why we want to make everyone aware of how to go about maintaining that information confidential in light of the amendment. But it may be worth determining what information should even make it into a document before it's filed, which would then again, of course, remove any of this part of the process, and it would just follow our normal process at this up to date. This excellent recording PowerPoint be available on Know Before You Know filing page. Let me look at our communications director or Leon. Yes, so it'll be on Facebook.
And we'll email all the people that registered.
Okay, so then we will email everyone. All registered attendees will receive an email with the information to the Facebook page, which will have this recording as well as the PowerPoint. And again, if you haven't, again, the myorangeclerk.com /know before you file also has some information that will hopefully be helpful and useful for everyone. If you have any other questions, thoughts, comments, I mean, we're here to, again, try to educate everyone. I thought it was interesting when the Florida Supreme Court included that language in the opinion about the sanctions that are included within the rule. And I thought, oh, wow. I mean, again, if someone's information, your client's information gets out and someone says, oh, but your attorney didn't notify you of this, that was one thing that really prompted Clerk Russell and our staff to really think about getting ahead of this. And again, trying to enlighten, our partners as far as what this change would mean for them as well as their clients. And thank you, Bob. We appreciate that. Melissa, I want to ask you one question. Well, not a question, but more so point of share something about the self-help center. So for for those that, I know maybe you all don't take on every case you get, but I'll say we're enlightening, sharing information with our self-help center for pro se litigants so that everyone doesn't think we're just focusing on the bar, but we're also pushing out some information with the self-help center.
Oh, absolutely. Our self-help center is open Monday through Friday and holds attorney consultations on Monday, Tuesday, Wednesday, and Friday with pro se litigants in the small claims, normal civil as well as in some family matters. And we're trying to educate them as well when they come up to the front counter to file their pleadings. A lot of pro se doesn't file through the portal. We have information that we can share with them that they can walk away with, telling them they could file through the portal, as well as this new rule and how it could affect them in the future. So our front counter staff is being retrained on that verbiage. Prior to July 1st, it's not really a concern because we would do the redaction. But now that this has changed, we want to make sure that everybody knows that if you don't do this, your personal information is going to be out there for everyone to see.
Thank you. And just because, again, we sent this out, we spread this training out to everyone. And so everyone on this call may not be an attorney. So we just want to put that out there that if you are on the training and you are a pro se litigant, that there's information available for you as well to assist you with this, again, with this amendment that's effective July 1. So does anyone else have any questions, comments, or concerns? Okay. All right, so seeing none, we're going to go ahead and wrap up. And on behalf of Clerk Tiffany Moore Russell and our entire clerk team here, we greatly appreciate you tuning in. We hope you found this information to be insightful and helpful. And again, we encourage you all to continue to check our website and look for information as things progress. And of course, trust that if any information we receive with any changes or any further guidance that we receive, we will be sure to try to push that information out to you all as soon as we receive it. So again, thank you for joining us, and I guess we'll enjoy the rest of your week.